Prosecutors in the trial of Derek Chauvin are expected to bring forward more police witnesses later today. It comes after lawyers for the state shifted their focus onto the ex-officers' training. Yesterday, we heard from two members of the police department. The chief and the former training director both testified that Chauvin's actions were not in line with the department's policy. Let's bring in CBS News legal contributor Jessica Levinson. She's also a professor of law at Loyola Law School. So, Jessica, the defense pushed back on the police chief's testimony, noting that there are several factors to consider when applying force to a suspect, including a possible threat from a nearby crowd. The defense keeps bringing this up, and I get it. He's trying to prevent his client from going to jail. But I'm just sort of curious about your take on that strategy when we're not talking about crowds, as we've sometimes seen. I get that the point that he's making is, in a situation, could a crowd turn hostile, which would then require a police officer to behave in a certain manner. But the crowd that we've seen on the video was not hostile. They were, well, let me rephrase that. They were yelling things and they were screaming at the police as they witnessed what they were seeing, but they never really got to the point where I felt that those police officers' lives were in jeopardy. I don't know what you think, though. You're the lawyer. I mean, is it a sound strategy to sway the jury to keep bringing up the crowd? I note that if it was in a different type of neighborhood, maybe that wouldn't be the issue.
Right. Well, and I think the question isn't, am I a lawyer or not? Because we're not arguing to the judge. We're not arguing to other lawyers. We're arguing to the jury. And to the extent that you're not moved, Vlad, I mean, that's really important information. You're asking basically, why are they arguing this? I mean, you argue the facts that you have. And I think the defense is faced with a number of really bad facts here. And part of what they're trying to say is, look, they can't make this group of bystanders who were voicing concern over George Floyd's death look like tens of thousands of people or even hundreds of people. But what they're trying to say, I think, in a number of different ways, both with respect to the neck restraint and with respect to the crowd, is that this was a changing situation. You weren't there. You weren't in Officer Chauvin's shoes. You don't know everything that was happening. And therefore, he had to deal with, at that moment, a number of different moving parts, and he was doing his best for public safety. Now, we might not think that's a particularly compelling argument, but again, you can only argue the facts that you have. And so I think this was part of what we saw from the defense throughout the day, which is even when you saw the officers breaking the so-called thin blue line, you saw the defense saying, but there really is no black and white line when it comes to excessive use of force. It's definitionally dependent on facts and circumstances. And that's what the defense is going to try and continue to bring out. You weren't there, you don't know. Let's try and imagine all of these different things happening. Again, will it be compelling? I don't know.
We also heard, Jessica, from the doctor who provided emergency care to Floyd when he arrived at the hospital. He said that the lack of first aid rendered to George Floyd as the officers waited for paramedics to arrive dramatically reduced the chances of reviving Mr. Floyd. How does that impact the defense's arguments, especially given that the chief of police and the training inspector both said and read from the Minneapolis police, guidance and guidelines that an officer is required to provide medical attention to a suspect if they need to?
Right. Well, this is the prosecution's case, and those witnesses were very good for the prosecution. And what does it do for the defense's case? Again, nothing good here, because what they're arguing isn't, or what the prosecution's arguing is not just that Officer Chauvin applied too much force, but that he continued to apply too much force and then was dereliction in his duty of care. And I thought that you asked me about the medical examiner's testimony. That was very powerful, where the medical examiner said, look, it's minute by minute, every minute that goes by, every 60 seconds that ticks by that nobody helps, that decreases your chances of survival by about 10 to 15%. People in the jury box understand what that means. It means that George Floyd maybe did not have to die if Officer Chauvin, the argument is, had not only lifted his knee off of George Floyd's neck, but had also then gone to his second duty, his duty of care to provide aid. And I thought that that was very powerful from the chief of police and then from Officer Chauvin's training officer, both emphasizing, I believe, this idea of we have to protect everybody, including the suspect. If they're in distress, we are trained in basic first aid. We do need to do something. And the medical examiner just helped essentially button up that argument, saying something could have been done, seconds mattered.
So, Jessica, if the defense attorney brings up a medical examiner or the medical examiner who conducted the autopsy on George Floyd, and that witness provides testimony that suggests that Mr. Floyd at the time had ingested numerous narcotics, numerous opioids, whatever it is that they ultimately share with the jury, because the doctor that testified yesterday said that based on the information that he had at the time, so he's an emergency room physician, he's working on Mr. Floyd in the moments after after his encounter with Derek Chauvin. If the medical examiner says, yeah, but there were all these other things that we found once we conducted the autopsy, is it then conceivable that the jury, because we should always remember that it's, beyond a reasonable doubt. If there is a doubt that, well, he had taken all these opioids and the medical examiner says, yeah, the doctor who worked on him in the moments after his encounter with Derek Chauvin didn't know what I know, which is that here's what I found once I did the autopsy. Could that sway the jury, at least one juror, to say, well, I have a question?
I think the defense is banking on exactly that, Vlad. I think that's exactly what they're hoping, which is that there's enough conflicting testimony with respect to the cause of death that one of the jurors says, is it really fair to say that this was murder and or manslaughter? Now, again, the defense is basically arguing three buckets. One, this wasn't excessive force. And we saw those arguments yesterday when the defense was cross-examining the witnesses, again, arguing, look, this is fact and circumstances dependent. The other thing the defense is going to argue here, that in fact, the knee, Officer Chauvin's knee on George Floyd's neck was not the substantial cause. So we're going to hear more on this issue that you asked me about. What was the substantial cause of George Floyd's death? And then that leads into that third and most important bucket that you also asked me about. Are we sure beyond a reasonable doubt that Officer Chauvin used excessive force and that it was the substantial cause of George Floyd's death? So yes, if the defense can bring forward experts that say, well, there are other contributing causes, we're not sure exactly what the substantial cause was, are you sure you want to take Officer Chauvin's liberty away? That's enough for the defense. That's game over.
All right, we will be watching. Jessica Levinson, we got to wrap it up a little early because I believe the trial has already started. So we'll talk to you, I'm sure, throughout the course of the trial. Thank you, Jessica, as always. Appreciate it.
Thank you.